You've probably heard or even said it yourself. Michigan is an at-will employment state. That means I can fire anyone, anytime, for any reason, right? Well, yes, and definitely no. I'm Jordan Held, an attorney at Kreis Enderle, and today we're breaking down what at-will employment actually means and what it absolutely doesn't mean. Because the idea that you can fire anyone without consequence, that's one of employment law's most misunderstood and most dangerous myths. Let's start with the basics. At-will employment means an employer can terminate an employee at any time for any reason or no reason at all, as long as that reason is not illegal. And the employee can quit at any time too, without giving notice. It sounds simple, but here's where it gets tricky. At-will employment is not a free pass. It doesn't override federal or Michigan employment laws. It doesn't protect you from claims of discrimination or retaliation, and it definitely doesn't mean no consequences. If you fire someone for an illegal reason, at-will employment won't help you. So what's illegal? Terminating someone based on race, gender, age, disability, religion, or other protected classes under state and federal law. Retaliating against someone for filing a workers' comp claim, taking medical leave, or reporting harassment, firing someone for whistleblowing or refusing to break the law, and letting someone go after they ask for a reasonable accommodation. In these situations, it doesn't matter what your handbook says or how long they've worked for you. If the reason behind termination is discriminatory or retaliatory, you could face a lawsuit. Let's say you have a chronically late employee or someone who's constantly negative and dragging down the team. Can you fire them? Yes, as long as you've documented the issue and can show a legitimate, non-discriminatory reason for the termination. Here's the rule of thumb. If you're going to terminate someone, you need to be able to explain what happened, why it mattered, and how you responded. That's why we always recommend progressive discipline policies and clear documentation, not to create red tape, but to protect your decision if it's ever challenged. Because trust me, when things go south, the question won't be, were you right? But can you prove it? At-will sounds broad, but there are plenty of exceptions. Let's look at a few common ones. Written contracts. If you've signed an agreement that guarantees employment for a certain period or limits reasons for termination, you've modified the at-will relationship. Implied contracts. Sometimes even a verbal promise or repeated pattern of behavior can create an implied contract, like saying, you'll always have a job here as long as you work hard. That can be used against you. Company policies. If your handbook says employees will only be fired for cause, but you fire someone on a whim, that could create legal exposure, even if your state is at will. And lastly, public policy. Firing someone for refusing to do something illegal or exercising a legal right violates public policy, and Michigan courts take that seriously. Again, at-will doesn't mean anything goes. It means you still need to follow the rules and be ready to show you did. Now that we've cleared up the myth, let's talk strategy. If you're an employer in Michigan, here's how to use the at-will employment the right way. Include a clear at-will disclaimer in your offer letters and employee handbook. Avoid making guarantees during interviews or onboarding that suggest job security. Document performance issues, warnings, and any disciplinary steps. Be consistent. Treat similar situations the same way to avoid discrimination claims. And train your managers. They're often the first line of risk, and they need to know what's okay to say and what isn't. You're planning a termination, especially for a long-term employee. Pause and talk to counsel first. Sometimes a 10-minute conversation can save you from a 6-month headache. There's the thing. The workplace is evolving. Remote work, shifting cultural norms, and increasing legal awareness mean employees are more willing to push back, and courts are listening. If your policies, documentation, or decision-making don't hold up under scrutiny, at-will employment won't save you. But if you treat it as a framework, not a free-for-all, you can build a stronger, safer business. At Kreis Enderle, we help Michigan businesses create the right policies, make smart termination decisions, and avoid legal landmines before they become lawsuits. Whether you're updating your handbook, managing a tricky employee issue, or just want peace of mind before letting someone go, give us a call. We'll help you ensure your at-will employment policies are working for your business, not against it. Because when it comes to employment law, what you don't know can definitely hurt you.